All right, hello everybody. Thanks for coming out to this exciting stream. Where instead of a call, we're going to be looking at Lorne's court documents. I have a special guest with me. That would be the illustrious Cybersqueak. How are you doing, Cybersqueak?
It's me, Squeaky.
It smells like beef burger.
This stream smells like 100% beef burger.
How you doing today?
I'm good. I'm good, and yo.
Good and you. Yeah, so we're going to be doing, specifically the August 22nd court transcript from where Maria in probation talks, and the government talks to the court about everything Lorne does wrong. So basically all of his probation violations, so it's going to be a good time.
This is a very good time. I've heard this before, but I've never actually sat and read through it myself. So
Oh, there we go. And first off, I'd like to thank you for the stream art for tonight. Your amazing Lorne doodle, which premiered a few years ago on GB's one of her streams, and I begged you for it.
yeah, I had to go through all my fucking files. And I was like, here it is.
I was gonna say I couldn't even find it because it wasn't like a thumbnail. I had to go through like 15 of her streams because she just brought it up randomly. And I took a screenshot. I was like, this one, because it was very hard to explain what I wanted. But I just think it's so Lorne. This is better than a picture of Lorne. It just details Lorne.
just melty and just small dick and naked.
Yes,
that's it.
And the pet of the stream is DJ Payne's one. Or excuse me, not DJ Payne one. It's I didn't switch the name. God damn it!
I was gonna say that doesn't look like Callie's Goofy Doofy babies.
Those are Callie's. 1 second. Hang on. Shit. Shit. See, I switched my layout at the last second, and I didn't bring the name over. Sorry, everybody. Oh, fuck, I just deleted it.
Oh.
All right, let me take a second and just fix this. Sorry, Callie, but DJ was from last night. This is Callie Slime Bucket Witch Ladies, 2 dogs, Opie, shit, hang on, I got it right here. Opie and Gypsy. Damn it, I didn't switch the names. I am so embarrassed.
Listen, as soon as I come onto a stream, it's just gonna turn into a shit show of hold on, I gotta sit here and fix my assets because that's all I fucking do on my stream.
Well,
so
it was the thing where here, I'll just for the people at home, I'll take this layout down. I have 2 layouts. One I have this layout, which is one I'm not using, and I have my wide layout because I want to share my screen. So I wanted everybody to be able to see it underneath the layout. So I got everything ready under that one, and then realized, I need my wide screen layout. And I brought the pictures over, but I didn't bring the name. So again, to reiterate, these are Callie Slime Bucket Witch Ladies dogs, Opie and Gypsy. So I don't know if she's here, but let's see. Let's say hello to everybody. We have I Am the Senate, Cybersqueak. I wonder who is Cybersqueak.
Who is Cybersqueak?
Dr. Cunt. Nice to see you here, Dr. Cunt. Thanks for coming.
I like how
Dr.
you say
Cunt.
that. That's very satisfying.
Cunt.
Dr. Cunt.
Everybody listen. You're a cunt. Anyway, we have Lorne's sisters, Munkled Leg, otherwise known as DNA, Asbury Brad, Carrot Gaming, Rod the Virgin, Rachel D, Good New Lifestyle Guru, Eel Reeg the Overrated. You're right, Eel, you are very overrated. Evil Little McNuggets, Hello My Love. It's mainly just Eel Reeg and Evil Little McNuggets for a long time in this chat. Let me scroll down.
Yeah, it's a lot of those too.
Cornville Counselor, Laura, Rachel D, Hey Boo, Page Master, Andy Birdcat. Anybody else we got here? Witcher at the Time Machine. Callie Slimebucket Witchley. There we go. I apologize, Callie. I had it all right on my other layout, but thank you again for sending in pictures of Opie and Gypsy. We now have it corrected. Moten G, my birthday is 4/25. Happy belated birthday again. Mandy S. Spencer Solvera. Homosexual Fruit. Nice to see ya. Brown Eyed Billy Batson. Yarn Queen. Dan Cubes. Man, we got a shit ton of people in here.
Right?
The Ghost of Tony Farmer, the Duchess of Cornville, Anthony R., Raider of the Lost Cod, Lawrence Burnphone, Sheffrey, Gorilla Face Gwen, Yabogan, nice to see ya. Amy A. Ramirez. Dark Atheist.
Gang's all here tonight.
I know. I just you Super J. This is what happens when I'm a few minutes late because everybody shows up on time and then starts chatting. Chat is chat, but showing up is showing up, and they all showed up. Smokey the Cat, R.I.P. I don't see anybody else. Oh, Anthony R. Nice to see you. And Dr. Cassandra Elizabeth Vaughn and Lorne Legweek. Okay, Pam Simpson, Disturbing the Pieces. God damn it. People just keep showing up. All right.
God, what a big chore. People showing up to your stream.
I know. Can you guys stop, please? I mean,
just leave. Go.
Please. It's a hassle. Anyway, so like we were saying, we have some of Lorne's court transcripts, and I would like to thank Kelp Pill for providing these to me.
Hell yeah.
She sent me a bunch of shit, which I would like to do in later streams. Hey, VJ. So, why don't we just get started? So I sent a copy over to Cybersqueak, so I hope you have yours up.
Yes.
So, why don't I'll take the first two. I'll be the court and Mr. McCormick, and you could be Mr. Morgan and Maria. Wait a minute.
All right.
Sorry. Appearances, McCormick. Yeah, I'll be the court and McCormick, and you be Morgan and Shockman. So let me get this up on stream so you guys can see. Did I miss the Glory Hound coming in?
Is there a Glory Hound?
Somebody just mentioned the Glory Hound. Egbert Mandingo, how you doing?
I don't see her.
Maybe that's just good and you being funny. Hey, Honest. Oh, that reminds me. I'll eventually put it. So we have two streams that are happening after us. So at 8 o'clock Eastern, Cornville Three-Way is going to be streaming. And then at 11:30 Eastern, Honest and Callie will be streaming over, I believe it's on Callie's channel. But
I think it is, yeah.
I'll throw some links. I meant to pin that. But of course, I was late and didn't have time to do anything. But
I'm telling you, I come in here and I fuck up everybody's groove, and they're like, "Oh fuck, where's all my shit?"
at least now you get to fuck it up from the beginning instead of coming in like 2 hours into a stream.
Yeah, there you go, there you go. I'm here for the long haul this time.
So anyway, like we were saying, this happened in front of the Honorable John C. Nivenson, the United States District Court, Bangor, Maine, on the 22nd day of August, 2019. They couldn't do this on August 7th. I mean, come on. It's right there. 8/7/19. Well, for our American folks, it would have to be, I guess the other way around. Wait a minute. Because we do month, day. And everybody else around the world does it wrong, and they do day, month. So.
Oh, hold on. Chatterbait Billy has a request from me. Baby, what the fuck?
That's a pretty good Lorne. Baby, what the fuck?
Baby, what the fuck?
You know who does a good Lorne? Is Callie's husband. She just posted I saw
that video. Oh my fucking god.
From their stream.
Walking across the goddamn house and just going, "What are you?"
Yeah, when they did their full stream, it was like Saturday or Sunday. I think I listened to it Sunday. It might have been Saturday night. But he was just throwing out all these impressions. So it was like it was Lorne and like anybody that people were asking for, he was just throwing them out. Howard Stern's penis, Matt Ryan, nice to see you, and Jerry Anthony. Queen has graced me with her presence. 9 p.m. Central. 9 p.m. Central. Did it change? Because it says 11:30 for me, which should be 10:30. Anyway, regardless, sorry, because we're tight for time here, so I shouldn't be just pussyfooting around.
I'm the absolute like monarch of pussyfooting, so this is probably the worst day to have me when you're on a tight schedule.
I know, and I that's what happens in my streams. I just want to talk to everybody. I just want to sit here and talk to the chat, which I did do a stream like that a few weeks ago where I didn't have any plan. I just kind of just talked to people and we just played stuff, like which I enjoy.
Those are always fun. Okay,
Callie did change it. So if it's 9 p.m. Central, that means you're going live 10 p.m. Eastern. But I'll throw the links in. So we'll get that in a second. Anyway, so I can't remember. So I'm the Court and McCormick, and you're Morgan and Shockman. Let me write this down so I don't forget. I'm the Court and McCormick. So I don't know if we'll get through this because it's like 26 pages.
It's pretty long.
But we'll at least get into it because there is some funny stuff. Anyway, so I guess I'll start. I'll just get through this first a little bit because, like, on page 2, it's like the court, McCormick, Morgan court. Like, I'll just burn through that real quick. So, thank you. Good morning. Good morning, your officer. Excuse me. Good morning, your honor. We are here in the matter of the government versus Lorne Armstrong on the defendant's motion to reopen the detention hearing. We did have a hearing on the issue of detention, and the court ordered that he was detained, subject to his ability to seek the court's reconsideration of that through reopening the issue. So I'm not reading this weird. It's just that it's somebody talking in a court and they have to take it down verbatim. So they sort of stop and start talking. So it sounds a bit goofy. Anyway, and at the time there was a question on whether Mr. Armstrong would be readmitted or part of sex offender therapy. That was at least one of the precipitating factors for the motion. And I know that was an issue that was not addressed, at least to my satisfaction, at the last hearing. And so as part of the motion, there has been an assertion that he is eligible and has found a replacement program. Assertion that he is eligible and has found a replacement program. So that's the basis of this motion. Mr. McCormick, for the government's standpoint, does the government contest the reopening, or does the government simply contest whether he should be released? Where is the government on it? Mr. McCormick. It's the latter, Your Honor. The court. The latter? Mr. McCormick. So where the government is not against reopening the hearing. Okay. But does believe that the defendant should be detained. Don't we all?
Yeah, I was going to say, that's a no fucking brainer right there.
Right, it's like 100%. Hey, Tiffany Rose, Mr. C. Sorry, guys, I won't really be looking at your chat because I have to put all my energy into reading because I'm stupid, so...
No. Only a little bit, it's fine.
It's fine. No, I have big-time dyslexia, so it's going to be... This is actually pretty nerve-wracking for me to read in front of 70 people right now.
Oh no!
Anyway, the court. Okay, and for the record, the information provided with respect to a possible treatment program wasn't available at the time of the initial hearing. So I would probably agree that the government's concession is consistent with the standard. So without objection, we'll grant the motion to reopen. And so then the issue becomes whether there are conditions that Mr. Armstrong could be released. No conditions. He's got to serve time, which I'm happy that he wasn't released.
Yeah, thank God.
It is the defendant's burden here at this point to establish by clear and convincing evidence. Mr. Morgan, are you ready to proceed?
I am, Your Honor, yes.
Are you going to proceed by way of testimony or proffer?
I guess it's proffer?
Proffer,
Your Honor. The evidence.
Okay, you may proceed.
The evidence submitted with the motion. The court made a determination when we were here last time, a couple weeks ago, that Mr. Armstrong carried the burden in terms of the risk of flight. There's been no change in circumstances. Is the court fine with me not readdressing flight?
The court, unless the government believes the risk of flight, I don't understand the risk flight to be the government's concern in any event. That's correct, Your Honor. Okay, Mr. McCormick, that's what it is. The court, okay, you may proceed. That's not what it is. Okay, you may proceed.
Okay, great. Then I'll just go right to the heart of the matter. Oh boy.
Here we go.
Whatever they say right to the heart of the matter, you always know some good shit's gonna be fucking... Alright. This was emphasized the last time, so I don't want to belabor the point. Just be efficient. But in terms of carrying his burden, the sort of primary piece of evidence that Lorne points to about risk to the community is the government's own petition. At this point, the revocation report's been made available too. There's no concrete assertion, even by the government, that he was a risk to minors in the sense that he was a risk from a sex offender treatment standpoint under his... Basically, the underlying conviction here, meaning he hasn't reached out to any young people on the internet, there's been no claim here that he has. There was no allegation that his drinking caused him to be a risk to the community. Namely, there was no... Sorry. Sorry, this whole thing is... I know it's their job, but just anybody trying to defend Lorne just makes me laugh. There was no allegation that, for example, he drives a truck, that he was drinking during working hours. No allegation that drinking caused him to reach out to minors on the internet. The issues, from what I understand it, are that he drank and lied, and that his lying and drinking caused him to be suspended from treatment. So there's certainly a hypothetical risk that if he's untreated as a sex offender, that he could be a risk to the community. So the conditions that Mr. Armstrong proposes to be released on would, in terms of the alcohol, first would be that he continue AA. Probation's acknowledged that in June of 2017, he presented his probation officer, I believe it was the probation officer here, with his AA chip. Wasn't it like a 1 week chip or something stupid like that?
It was the bare minimum, I think, to get a chip.
Like the day one chip or something.
Yeah.
He would continue with AA. He would be willing to be monitored by an alcohol device, again, which is one of the recommendations sought in the final report. And he also would be willing to enter into substance abuse counseling at the same time as his sex offender treatment. So that's to address any concern that his drinking would be a risk to the community, even though there's no evidence to show that it has been historically so far. The second piece is the sex offender treatment. I did speak with Mr. Hogan. He confirmed that Mr. Armstrong, and Dwayne Hogan is the treatment provider who suspended Mr. Armstrong. He confirmed that suspended did not mean Lorne was not allowed to come back. He confirmed that suspended, in fact, meant that he would be allowed to come back, but not until after he had been punished. He told me the reason for that was that if Mr. Armstrong was allowed to lie and return to treatment without any punishment, that, in his words, would spread like wildfire among the other people being treated, which is very fucking fair. That's absolutely fucking fair. I was
going to say, yeah, 100%.
It's a group therapy, and that's a fair reason. I can understand Mr. Hogan's position. I asked him if he had an opinion about whether Lorne obtaining counseling elsewhere, outside of his facility, would be sufficient to address his risks. And he told me he didn't have an opinion on that. That was his answer to me. We did find Lorne reached out to treatment providers. He found one here in the Bangor. Like, I find that hard to believe. I really find that hard to believe.
Yeah.
He found one here in the Bangor area. That's Exhibit A to his motion to reopen the hearing. They have immediate openings. They provide both individual and group sex offender treatment. I disclosed to them the basis of why he was seeking treatment, with them namely that he lied to his previous provider. They did not say that would keep them from treating him. So at this point, he has sex offender treatment services that he's willing and able to pay for. He's iffy on the able. On the able.
I was going to say willing and able. I'm sure that is a check in the no department. Like, he fucking wanted to not pay his electric 1 month just so he could give Roy $100 for some reason.
Yeah. Yeah, he is the worst with money, and I don't know how. Like, I think that I'm okay with money. I'm not like an expert, but it's like, holy shit, what are you spending your money on? I really don't know. Where does it go?
Sheetrock.
Yeah, sheetrock.
It's just, Lorne is the classic get rich quick kind of guy, but he's just an idiot. So he thinks like, yeah, to buy all, these Beanie Babies, because he remembers from the 90s that they were, a big thing, but he doesn't realize that they've completely fallen off. So
I fucking love that so goddamn much. Like, that's so Lorne, just him buying fucking Beanie Babies. That's just a very Lorne thing to do.
And it's like he goes to these dumps and just buys shit to resell for, 10 times what he paid for it. Like, nobody's gonna buy it. And all the shit he buys, he keeps outside in his yard, just getting
under a tarp, getting rained and going through all the elements. So like, nothing he has probably works.
We've seen those pictures of his yard sale, and it's just garbage on table. Like, it's disgusting shit sitting out on these tables. Like, for like, just broken stuff for $5. Like, who's gonna? He thinks he's gonna survive for a year. Like, he's just gonna go every May to every 10-mile yard sale and just make a full year's earning to live off.
Which in reality, I don't remember. I think it was in one of the robocalls. Like, I think he said he barely broke even. So it's like,
well, because nobody buys his shit.
Yeah. And I think the people he sold to was like his mom, and he didn't even give her a discount because he's a fucking cheapskate.
Right.
Oh, God. He's willing to be monitored from an alcohol standpoint, and there hasn't been any allegation that either of those two things, either the lack of treatment, I'll put that aside, that his drinking caused a direct risk to the community. I mean, he drives drunk, so.
Yeah, he drives drunk quite often.
And he's addressed the issue of under treatment counts by finding new counseling. So based on that, he's carried his burden to show by clear and convincing evidence that he should be released. This isn't a question about whether he should be punished, simply a question about whether he should be released pending the final hearing.
The court, thank you. Mr. McCormick? Mr. McCormick. Yes, Your Honor. First, just in terms of the drinking, the government takes issue with the fact... Hang on, this looks weird. The government takes issue with the fact that he's drinking doesn't lead to an increased risk. The government believes that it does. Of course it does. Like 100% it does. And in my conversations with probation is that when you drink, your inhibitions are less. And based on his prior conviction, I think it does increase the risk. Now, there is no evidence that I've seen at this point that he has reached out to minors, but I think drinking in combination with his prior history is a risk. That sounds like a pretty logical conclusion there, Mr. McCormick.
I mean, anybody who drinks is at a risk of doing risky behaviors.
Right, yeah. And, I mean, if he had internet access, he would just drink and get on and, I don't know, be horny and just look for whoever, you know? Like,
yeah. It would just be Nashville all over again.
Right.
Just the same shit.
And in addition, Your Honor, I do think that it's significant that these are not one-off drinking things that he has been involved with. I mean, one of the statements from the petition say that on July 24th, 2019, Armstrong admitted to probation he had consumed alcohol on July 7th, 2019, and reported he had been consuming alcohol on a weekly basis since the complete of SoberLink testing on, I guess that should be completion of SoberLink testing on December 4th of 2017. And he consumes on average 7 to 12 beers in a sitting. It's more like
that's
18.
Being generous. I was gonna say that's. Oh my God.
They split like a 38 pack or 36 pack or whatever. Like
that's a generous number right there.
Yeah, he's getting close to 20 each time. And even though if it's true that Lorne only ever drinks on Saturday when he goes over the Tonys, that's still an alcohol problem. He's drinking so many and he's driving.
And he's still violating his probation. Like it doesn't matter if it's like one fucking beer. It's you're violating your probation, dude.
Right. That's what he likes to say is like it's only one a week. It's only one time a week, so it's cool. Probation's cool with it. It's like no, you're supposed to be 0.
Yeah, and the thing is, if I remember correctly, his original terms of probation were. They didn't even say that he couldn't drink alcohol.
Yes.
They just said you couldn't drink in excess.
Right.
So he fucked that up.
It's like all he had to do was not drink that much, and he couldn't not do it. They gave him an inch. That's the thing with Lorne is when you give him an inch, he takes a mile. He's that kind of person. But they literally told him he could drink, but just don't get drunk. Well, he got drunk, but not drunk. Or
not drunk.
Not drunk. So I think the risk, Your Honor, is not only that he seems to have a very serious issue with alcohol, but also that he seems to just frankly be ignoring the rules. Yes, thank you, thank you. That's all he ignores all of his rules. But also that he seems, which I think is a concern that he finishes his SoberLink training. He thinks he can continue to go out drinking without any repercussions, and I think the fact that he is willing to ignore those rules in combination with the fact that we do have evidence as well, too, or at least that there is an allegation about his involvement in getting a smartphone, which, again, is ignoring the rules that are clearly laid out for him. I think those are all risks to the community, and I think that basically, what I feel like is happening in this case is that he gets kicked out of sex offender program and he goes and finds another one. That I'm not sure that really addresses the risk involved. Yeah, Lord, I know he was kicked out of at least one, but was this the second time he got kicked out?
I think this is the first time.
Okay, because I know when he because he says that whole thing that they changed providers and so he had to go find a new one. Where to me it's that he got his ass kicked out, but he has to have his Aunt Sharon, go on the internet and try to find a sex offender class.
Yeah, he had to stand behind whoever was on the computer and tell them what to look up, which was violating his probation, by the way.
It's funny. Like Lorne really thought he outsmarted everybody. That if he just stands behind somebody, tells them where to go and click on and what to search, that he's not violating his probation.
Yeah. Well, they told me I can't physically touch it. It's like, what, dude? What the fuck are you talking about?
There's a stream, I think, on Wine Lovers channel with Tiffany and Shins, and there's a stipulation in his thing that he signs every month with Maria that says he will not use the internet via a third party. And so it's like, you just... it just proves that he doesn't read.
It's that, and he thinks that he just doesn't listen. Like they say, he doesn't follow the rules.
No, Carrot, I'm not showing any issues on my end that the stream is fucking up. Might be on yours. Hopefully.
Try a refresh, sweetheart.
Yeah. Shit, where was I? Okay. So I think the detention is appropriate, Your Honor. The court. Do you know what the guideline range is if there is a violation here? Mr. McCormick, I'm...
3 to 9 months is my understanding.
3 to 9?
Yes, Your Honor.
Thank you. Probation some of these are worded really funny, and I know it's because the person has to type really fast, but... Probation.
Well, remember, they're in Maine, so...
That is true, yeah. Probation want to weigh in on this or add anything, Officer Shockman?
Oh, hell yeah, I get to be Maria now. Your Honor, I would just add that, like it was already stated, that the alcohol is an issue with lowering inhibitions. And there was an issue with Mr. Armstrong throughout supervision in having conversations over the phone with females that he had never met, and we could not determine what their ages were. So that continued interaction with people online that he is unaware of who they are goes back to his original offense, and that is a risk.
Tell me the relationship between his conduct that you were monitoring and the original offense.
Ooh,
here we go.
Boy.
This is the juicy part, guys.
The original offense had to do with having a conversation with a person he believed to be an underage female online. That he continued to have this conversation, and then he went to meet with this person, but it was actually an undercover agent. And that, in the eyes of probation, correlates with the same behavior now of having conversations with females on the phone. We don't know their ages. We can't confirm if they are adults or not.
And what was probation or some law enforcement able to monitor the substance of this communications?
We were not able, to a limited degree. We were checking text messages, and we would receive anonymous emails and phone calls about his behavior with links to recorded conversations he had with females over the phone. One of those conversations that is included in the revocation report, he had asked one of the females to provide sexual images of herself and to send them through the mail so that probation would not be able to find them.
How long ago was that?
May I check my record?
Sure.
That was in February of 2018.
And has there been any of these communications, or any communications that have been checked, to your knowledge, have they involved in any way somebody who was a minor?
So, there was a conversation that Mr. Armstrong...
So nothing ever. If you're asked a question and you say "so" to it, like,
I can imagine Maria felt so fucking good saying all this shit because she was like, "I'm so fucking tired of Lorne." So there was a conversation that Mr. Armstrong, he had called me on the phone. This is not highlighted in the report, but
approximately when was this?
This was approximately 5 or 6 months ago.
Okay.
That he had called me and asked a request to move.
Here we go, guys.
This works really good. Or go out to California to meet with this individual he had been speaking with over the phone, that he had never met. We had no proof of who she was, and he was informed by associates of hers that she was in the ICU and she was very sick. He had requested...
It's me, Winnie.
It's me, Winnie. I'm dying, baby. Yeah. He had requested to go out to California and to marry her as her last request. Bruh, marry her?
Like, that would be her last... Like, somebody's dying wishes to marry Lorne Armstrong.
I guess Lorne thought, like, oh shit, Lorne, your fiance is okay, you know what? This is Make a Wish for Winifred Pollard.
Yeah, right.
Go on out there. Uh, marry her as a last request because he was informed that she may pass away. And he had sent me an image of a female that he believed to be this individual in the hospital. Upon doing an exam on that image by my office, we found out that that was actually an image of a 15-year-old girl who was in a coma based out of a London newspaper.
And if I shared that photo on a stream a while ago, if people remember that, the court, the photo was out of a newspaper.
Yes, that somebody had sent to him to make him believe that it was that individual. And that is very concerning to US probation because that proves my point that we don't know who these people are or what their ages are. And he was under the impression that this was an adult female when in reality, this was an image of a 15-year-old girl in a coma. How much you want to bet he looked at that picture and he's such a sick fucking freak, he was probably jerking off to that picture?
Oh, I don't believe, there's no doubt in my mind that he jerked off to it when he got it. Because, like, not necessarily that it turned him on, but when he started jerking off that night to Winnie, he, like, it was like one of the only pictures he had that he can sort of see what she looked like. So,
yeah.
Oh, yeah, 100%. Yeah, honest, the stenographer was probably laughing so hard. He had received that image?
He explained to me that this individual's associates had sent him that image over the phone.
Is it apparent? Is the person's relative age apparent from viewing the photo?
No, Your Honor. She looked young, but I could not tell that she was of age or not.
And how was that resolved? Was he granted permission to go? Was he confronted with what the reality was? How does that resolve?
Can you imagine if they're like, yeah, Lorne, go out there, have fun.
Yeah.
And then he just is left at the fucking airport with
Right.
nobody to come pick him up. Oh my God. Yes, his request was denied. And I explained to him what we had found, that this was not the person he thought it was. And he was very upset that they had lied to him. But then months later, he continued to engage with those same individuals who had been lying to him.
What? No way.
What? No way.
You mean the associates of this person?
Yes.
Or the purported associates of this person?
Yes.
Okay, and how long did that go on?
To my knowledge, that has continued to go on throughout his supervision.
Continue to communicate with these individuals?
Over the phone.
And where are they located, do we know?
We do not.
Are these women?
Yes.
And the government has mentioned, and you have mentioned, alcohol consumption as being an issue. Is there any evidence of alcohol use during, like, this incident with the communications with the person who turned out to be 16 years old, or her associates, anyway, or any of the other communications about which probation is concerned?
So one of the links that U.S. probation was sent, there was an... I just love the image of somebody going on YouTube, like fucking Maria being like, who the fuck is clobbering time? Like looking at the fucking channel.
Well, yeah, and that's
like,
what's funny is they still monitor Clobber's channels. It's like, hey, Kelpill. Again, thanks to Kelpill for sending me these transcripts. And you're right, Kelpill. Transcripts are overrated.
This, you know what? You got it from Kelpill. It might be fake. You never know.
Could be. Is it you?
So one of the links that U.S. probation was sent, there was an audio clip of Mr. Armstrong having a conversation with a female over the phone. He appeared, or he sounded as if he was intoxicated. He was slurring his words. So we confronted him about that audio clip, and he had admitted to my supervisor that he had been drinking during that conversation, and that was in fact him on the phone.
I note on the docket that there was relatively recently, within the last month and a half or so, a request that was not objected to by Mr. Armstrong for a modification of his conditions, which imposed, I guess, what I would consider the computer monitoring condition or internet monitoring. Is that right?
That was updated language recently.
Right.
It
was already there, wasn't it?
Yes.
And what was the reason? Was there any particular reason why it was modified in July? Or was that just modified language that became standard from probation's perspective so that they sought to modify it in every case in which the computer monitoring condition had been imposed?
That's correct.
Okay, all right. So sorry, I'm getting all mush mouth. And so what is probation's view on the proposed release plan?
The proposed release plan in reference to the treatment sought, my one question was, when we were sent the information about the program, it had listed all the costs. Because this is not a contracted provider, probation would not have the ability to pay for that. Regardless of that, though, like already stated, we do not feel that it reduces his risk because of his continued lack of compliance.
And in terms of the information that probation has available, approximately when was the most recent time you believe Mr. Armstrong made contact through means of internet or otherwise with someone with whom he was seeking to engage in some relationship, a woman or somebody, a female that he was looking to engage in some relationship?
Approximately within the last 2 months, he has continued to do that. That looks so fucking bad for him, man.
I know.
That looks so fucking bad.
She should have just said for the last 2.5 years. Like, just the fact that she just says last 2 months.
Yeah. Oh my God.
He has continued to do that. And how was that evidence brought to your attention? How do you know of that?
He continued to bring up the issue of these females to probation because he wanted to be allowed to continue to have these conversations. And he believed that continued conversations with these females would, because there are many people on the internet that have posted very negative information about Mr. Armstrong. And he thought that the continued conversations with these people would help vindicate him in some way. So he would continue to talk about it with probation.
And do you know how he made contact with these individuals, and whether the means of contact was permitted under the term or not permitted by his conditions of release?
He had been told multiple times not to engage with these females because of our concern that we did not know who they were or what their ages were. In addition, he was initially trying to talk to these women and individuals online about his crime and how he didn't do anything wrong and was trying to sell items associated with his case. Oh, that's so good.
I don't understand that.
Me fucking too, man.
Me too, Judge Niverson or whatever his name was.
So initially, when he was allowed to have internet access, he had a YouTube channel where he was trying to sell hats and other items because he had garnered a lot of internet attraction from him being on TV from his original case.
His original case had some TV relationship?
Yes, he was on To Catch a Predator.
And so when was it that he was permitted to have internet access? And then was it shut down at some point?
Yes.
So how long a period of time that he was allowed to have this internet access, and when was it changed?
From approximately 2015, before I had the case, with Officer Oswald until 2017, when we started receiving anonymous emails about his behavior online, and my office then restricted the internet access.
As of 2017?
Yes.
Okay, and yet you maintain that and have evidence that he continued to after that?
Yes.
And the people that he's been speaking with most recently, your evidence suggests maybe as recently as 2 months ago, was there any way he could have contacted them other than through the internet? Do you know?
He was speaking to them over the phone.
You don't I guess it's supposed to be you don't know how the first contact occurred?
No.
All right. It could have been or could not have been, but you don't have any evidence that it was via the internet, right?
There was these people stemmed from a group that were online that were following him because of his original case.
Okay. All right. So is that where, when you talk about these women that he had spoken to, were all of these similarly situated in the sense that they had followed him in some way on social media or whatever, because of this, his prior case, or do you not know one way or the other?
Some of the individuals.
Some?
Okay.
He just cuts her off. Sorry.
Yeah, he had indicated.
All right.
As to all of them, I'm not sure.
All right. Is there anything else that you'd like to add?
No, Your Honor.
Okay. Mr. Morgan, is there anything you'd like to address, or is there anything you'd like to ask for probation of Officer Shockman? Given my inquiry, you should feel free to do that as well.
I would just address a couple things. And if Officer Shockman thinks that I'm being inaccurate, please stand up and tell me, kind of, so I think it might be the easiest way.
Sure.
I do think the context of what has happened with this case is important, and I should have mentioned that before, but now Maria has gone through a decent amount of it. This isn't attention that he necessarily wants when, vindicating himself, etc. I mean, there are people who have been sending inappropriate emails to his mother, who's here today. Mama Gwen!
They've also sent him naked pictures through the mail. It's not just email.
The internet is a terrible place for things like this, and the reality is that he can only control so much of this. So I think that any sort of notoriety that he has should be viewed from that context. In terms of the 15-year-old or 16-year-old, I forget which age once it was analyzed by probation, it's a prime example of him apparently following what he was supposed to do on probation. He reached out to them, he told them, he asked for permission was denied, and he didn't go.
Wait, but he's making it sound like Lorne's doing this because he's been instructed to by probation. The only reason he sent them that photo is because he wanted to go there. He wouldn't normally just send the photo.
Yeah, it's and again, it's like, I get that this is his defense lawyer and this is kind of his job, his job, but like, Lord doesn't get a pat on the back for following his terms of probation,
Yeah, it's what you're supposed to be doing.
It sounds like he has people looking to set him up to fail on the internet, and he may have poor judgment about who he should be interacting with. But so long as there's evidence that he's trying to clear things with probation and not going over their head, then I think that's an example of him doing what he's supposed to do under his terms of probation. So there's no reason to think he wouldn't do the same if released on conditions. The relationships with adults, there's no condition if he's not allowed to have either sexual or, for that matter, friendships. He tells me these are friendships with people who are of age. He's allowed to have relationships with people. It'd probably be healthy for him to do so. So I think so how much you want to bet when he heard his defense lawyer say that? He was like, the lawyer said that legally I should have a relationship. Like,
oh, yeah.
Stupid shit like that.
Mm-hmm.
So I think him interacting with people in and of itself, especially if it's by phone once he's not allowed internet, is appropriate. And, again, evidence that he's willing to follow conditions. It's his drinking that he's had trouble with, and he needs counseling for that. And he's willing to do counseling and have the monitoring device as a condition of release. So I think his disclosures to probation actually bode in his favor. And I forgot to mention, but he would be willing to obviously execute any releases necessary with a new treatment provider, so probation would have all information with them and be able to contact them.
Thank you. Mr. McCormick, anything you'd like to add? Nothing further, Your Honor. Thank you. And did you have any questions you wanted to ask Officer Shockman? No, I do not, Your Honor. Okay, well, I'll return to the kind of what brought us here. At least in part. We had the initial appearance in the hearing on the issue of release or detention, and at that time, and this is sometimes, unfortunately, what we're presented with, where at the initial appearance and the requirement that somebody be seen without unnecessary delay, usually the same day, sometimes challenging for all parties to be able to garner all the information necessary to those decisions. And I think at the time, Officer Shockman, who just provided, a fair amount of information here, was out of state on office business, but was not present. And so there was another probation officer who had pinch hit for her. So we were somewhat limited. Everyone was somewhat limited in the information. And at the time, the issue seemed to be Mr. Armstrong's dismissal or suspension from sex offender treatment program due to his lack of candor with respect to his drinking, and how that affected the ability to main of the group, him to continue in the group. And I think Mr. Morgan has shared with us Mr. Hogan's reasoning in that suspension, which again seems to make some sense in terms of how immediate return without any consequences that they can point to may affect the group's dynamic and the ability of the leaders of those groups to hold people accountable. So I can understand that. And so at the time, if the issue was whether there could be some other treatment program to get him engaged in and also address the substance abuse problem, then it may be a case where he could be released. That's kind of the history that brought us here. And today, what's been proffered is, in fact, a plan to address both the substance abuse issue and the sex offender treatment by getting, in essence, treatment and monitoring in both cases. And the defendant's agreement here, it does have some appeal in that it seems to address the issue that were of concern. And frankly, if that were all, the only information that was presented, I think I would maybe look favorably upon Mr. Armstrong's request here. Why? Because all he's done is, just gone against probation.
Yeah, I don't know. I guess the judge is trying to be fair here, but it's like, nah, you don't need to be fair with Lorne.
Thank God we got Judge Woodcock on the next one. I must concede that the information that has been shared today regarding Mr. Armstrong's conduct while on probation is concerning. I have no basis to say what the motivation was. Mr. Morgan makes a valid point in that there's nothing that I'm aware of that prohibits Mr. Armstrong from engaging in communications with, relationships with adult women, and there's nothing that the underlying allegations are not suggestive of any misdeeds in that respect. I mean, I understand what he's saying there, and yeah, Lorne's allowed to be in a relationship with women, but him jumping with these relationships, like, it still shows his predatory nature. So it's not a good thing that he continues to act this way through the internet and meeting people like this.
Like obviously they legally can't say, Lorne, you can't date people, but it's like there's got to be something they could do with him, because it's clear that he's a predator.
Right. The concern that the information here raises are as follows. One is that Mr. Armstrong has, it sounds like, fairly consistently while upon release deliberately engaged in conduct that he knew was prohibited by his conditions. The alcohol,
no shit.
Yeah. The alcohol is the most obvious. The alcohol use is most obvious. Oh, he said it twice, so I didn't fuck that up. Okay, good. The use of the internet and devices he was prohibited from using is another one, and that's challenging to monitor. And perhaps one of the most concerning things that I heard was his attempt to deceit when he was told, and again, I know this is by proffer, when he said, and I think I understand that there's evidence of this from at least somebody who has reported to probation, that he asked that explicit photos be sent, and granted, not of a minor, but be sent in a way so as to make sure that probation was not aware of it, and if, in fact, Mr. Armstrong was engaging in behavior that he knew was permissible and appropriate, there'd be no reason to be concerned about whether probation was aware of it or became aware of it at all. None. Boom, just bring the hammer down on Lorne right there.
Mm-hmm.
It's like, well, why would you go, I just love that. And Lorne probably doesn't understand a word that he just said. It's
the concept of mailing nudes in the mail is really fucking funny to me. Like, like, you imagine, like, old days, like, they just have a big old fucking painting of some dude's dick, and they're like, oh, my lady, a painting has arrived for you.
Yeah, you're sexting, it's just mailing stuff back and forth, and then you get a letter that just says, send nudes, and it's like, okay, you gotta call the artist, you gotta sit there for 12 hours,
Now the artist has to see your titties out, like...
We gotta get all your clits right, And this continued, and again, I don't know the full backstory to the prior case, and the fact that, at least from Mr. Armstrong's perspective, he's attempted to kind of clear his name in the public domain, or would like to clear his name in the public domain, and I can appreciate that if, in fact, there is information out there that is hurtful to him and his family. I can't today assess that that's the it may well... Sorry, sometimes when he talks like this, it really fucks me up. I can't today assess that there's see, it's like messing with my brain, 'cause it's not a word. He's starting to say motivation, and I don't know how to say it.
I've read, like, when I did on yesterday, I did a reading of, like, Joran's fucking writing, and it's like you want to correct it, you want to fix it, but it's like you have to read it as it is, and you get confused.
Right. It may well be the motivation. Another interpretation, however, I think, although Officer Shockman did not articulate this, it seems to be at least implicit in probation's position and assessment here, is that another interpretation is that he welcomes the attention to some degree. Yeah, 100%.
Oh!
100%. That's man, I can't believe the judge just said that.
That's so fucking spicy.
If the information about selling items or memorabilia or something that commemorates this, the incident is accurate. I don't know what it is. It's been proffered here today as something that occurred in the continued interaction with people affiliated with that case, and the notoriety that went with it can be interpreted as wanting to facilitate that, or as opposed to clear his name. And again, I'm not making any determinations as to what the motivation was. I'd be hard-pressed based on the evidence through proffer to make that determination. But I point all those things out because those are concerning factors, so that if you were to look at this and say he has an alcohol problem that's untreated, he's continued to engage in what can at least be construed as risky behavior in the sense of risking a proceeding like this. And what's compelling him to engage in that when he knows that this is the consequence, that's really concerning, and presents that just underscores that safety concern. And when you have those two potential interpretations, oftentimes in cases it comes down to the burden of proof. And not only does the defendant have the burden here, it's a high burden. It's a clear and convincing evidence standard. And the requirement, what I would have to do to say that the safety concern that has at least been presented today, which is much more crystallized than it was when we were together last time, I'd have to find that by clear and convincing evidence that the conditions would address the safety concerns. Well, objectively, you may be able to say, look, if he addresses the alcohol and if he gets back into sex offender treatment, that should do it. Well, with somebody who has been in compliance and hasn't been, made attempts to engage in conduct without detection by probation, and engaged in conduct that was in deliberate violation, and there's no argument to be made that he didn't, wasn't aware of the conditions. I simply can't get to that level of clear, and that I'm convinced by clear and convincing evidence that these conditions would address the safety concerns. I do appreciate the fact that, Mr. Morgan, you have taken the steps to address the concerns that were raised at the initial appearance here. I'm certainly sensitive to the fact that when the court identifies the areas of concerns and then somebody attempts to address those concerns, there's a conclusion that it's not sufficient. It's not sufficient in the instance because of the additional information that is available to me now that wasn't then. And
understood.
Had it been available, I probably would have identified other areas of concern. So I do not want you to think that your efforts were for naught or not appreciated by the court in your attempt to address the concerns.
Understood. Thank you.
I understand them. So while we're going to grant the motion to reopen we have granted the motion to reopen the detention hearing, I'm going to deny the defendant's request for release upon conditions for the reasons I've just articulated. Yes, Lorne, as soon as he heard that, I would imagine he probably started crying, or at least trying to fake cry so that he could get sympathy. God. Are there any other issues that the government would like to... I scrolled down too quickly. Are there any other issues that the government would like the court to address? Nothing else from the government. Thank you, Your Honor. Mr. Morgan, anything?
Nothing else, Your Honor. Thank you.
Officer Shockman, anything?
No, Your Honor.
Thank you. We'll be in recess. Proceedings concluded at 10:49 a.m. Well, there we go. Maria just laid down everything he's been doing, and the judge, just basically owns him there at the end. And what's great is that he refuses to release him.
I would have loved to see Lorne just fucking crying at that. Like, oh God, Mom, they didn't let me go.
Yeah, I'm surprised he didn't turn and be like, can you get up on the stand? Like,
Yeah, not so surprisingly, when it comes to like actual like prison and like authority, he's such a pussy that he just kind of like his tail goes between his legs, Yeah, and you
really get that in the other transcripts from his sentencing hearing, like in a few weeks from now. He's very neutered, and at least in the sense that he doesn't like... I mean, we'll get to it when we read those. I mean, we could probably start it.
Yeah, we can start it.
The other one's pretty long. Here, let me send it to you. 1 sec. Get up, Cyber Squeak. Let me send this over.
Who's that fucking Cyber Squeak?
You better get that Cyber Squeak out of our lives. Okay, I just sent that over to you, so if you want to bring it up. So, in the meantime, I guess I will just address the masses. Hey, Witcher Omega Hebear, how you doing? Ghost of Tony Farmer, nice to see you, buddy. ADD, Nate Diaz, Army 209, Johnny Utah, C Mogul, that fuckhead Cornville 3-way, Zachary Stanford, nice to see you.
Did you let him out? You let him out, right?
I did let him out. He is streaming tonight,
Good.
so I let him out.
You freed him. Run away, Cornville 3-way, run!
Oh, I'll catch him. He gets to the airport, but I have a guy there that always grabs him.
Corrals him back.
Yeah. Hey, Zachary Stanford, Kazanton, Patrick Mo Adib, how you doing, buddy? Okay, I think that's pretty good for people who are in here now. Oh, La Senorita, nice to see you. Asbury Brad, how you doing? Okay, let me get this up. Hang on. So I guess we'll have to figure out.
Allison Marie Armstrong, you go right ahead and print that off. I do not mind if you do that.
What did she say? I'm dead ass serious though. I want to print off this pic for my living. I can send it to you, Allison, so you can have a nice.
You have full permission to print off my artwork and put it on your walls.
I honestly think I want to order a sticker and put it on my laptop. Like trim it so that it's the outline. You should probably put it up on Redbubble or something.
I was gonna say, should I make a Redbubble and just have that as the only fucking thing on there, just a sticker? Yeah.
It should just be. It should be called like Pedo in the Nude or something, or something. Like, don't name it Lorne so they can't find it. You know what I mean? But hang on one sec. Let me get this up. Hang on, baby. Okay.
Right, Kathy Mack? Like, listen, it's the lawyer's job to fucking defend their client, but it's like, you really, I feel bad for his lawyers because they're just like, oh boy, gotta defend Lorne Armstrong today.
Yeah, it's kind of like an impossible task almost. It's like,
yeah,
you know. All right, shit. So, I will. How many people are in this? Okay, here. How about this? So I'll be the court again. You can be Lorne, and
oh hell yeah,
and his attorney, Mr. Morgan, again, and I'll be the court and Mr. Casey.
All right.
Okay. So are you on page 2?
Yes.
Okay. Defendant present with counsel in open court. The court. All right. We're here in the matter of United States versus Lorne Lynn Armstrong, which is 13CR11JAW. If I ever, like, get a job with, like, Lucasfilm or something and I do Star Wars stuff, I think that I'm going to name a robot, like an android or somebody, like 13CR11, you know, or something. just like... Yeah, get
name it 20014 after his fucking
That's
username.
True. Yeah. Would counsel please enter their appearances? Mr. Casey. Joel Casey for the government.
And Matthew Morgan for Mr. Armstrong, Your Honor.
I would note that Bryce Turgeon is present on behalf of probation. Mr. Armstrong, would you stand? Oh, God. Anyway, Mr. Armstrong, the purpose of this hearing today is for me to determine whether you committed any of the violations of the terms and conditions of your supervised release that the government has alleged. If you have committed any of these violations, to determine what punishment should follow as a consequence of the violations.
Yes, sir.
Do you understand why you are here today?
Yes, sir, Your Honor.
Sorry. You're going to make me laugh the whole time. Now you understand that you have a right to be presented by an attorney throughout these proceedings.
Yes, sir, Your Honor.
And, in fact, Mr. Morgan, the gentleman standing beside you, has been representing you in this matter, correct?
Yes, sir, Your Honor.
Everybody drink when he says, yes, sir, Your Honor.
Yeah, he says it like 12 fucking times on this page.
Have you been satisfied with Mr. Morgan's services?
Yes, sir, Your Honor.
And do you authorize him to act and speak for you throughout the course of these proceedings?
Yes, sir, Your Honor.
Have you received written notice of the charge violations?
Yes, sir, Your Honor.
Have you had an opportunity to discuss these charges with your attorney?
Yes, sir, Your Honor.
And do you understand the charges being made against you?
Yes, sir, Your Honor.
I've been informed in advance that you wish to admit violations 1, 2, 3, and 5. Is that correct?
Yes, sir, Your Honor, I do.
Before you do so, I'm going to ask the prosecutor to stand up and set forth the evidence that the government would bring to bear if the matter were to go to a formal hearing. I'm going to ask that you carefully listen to what Mr. Casey has to say, and after he has finished, I'm going to ask you whether you wish to have a hearing on whether you committed these violations, or whether you wish to concede that you committed the violations I listed. Do you understand what's going to happen?
Yes, sir, Your Honor.
You may be seated. Mr. Casey? Mr. Casey, Your Honor, according to the petition filed by the United States Probation Office on July 25, 2019, the U.S. Probation Office alleges, with respect to the first charge, that Mr. Armstrong violated Standard Condition Number 7, which requires him to refrain from excessive use of alcohol. According to the petition, the evidence of that violation would come in the form of the testimony of representatives of the U.S. Probation Office who observed Mr. Armstrong in an excessively intoxicated state on September 15th, 2015 and October 7th, 2015. I think that's when they showed up and he was naked running around his house.
No, I think that was a couple years later.
Okay.
I think they bring that up.
Shit, what did I just do? I just blew the page. Anyway, next, the U.S. Probation Office charges that Mr. Armstrong violated the special condition requiring him not to use or possess drugs or alcohol. Evidence of this charge violation would come in the form of testimony of representatives of the U.S. Probation Office who would testify that on May 4th, 2017, July 26th, 2017, October 4th, 2017, April 16th, 2019, June 28th, 2019, and July 24th, 2019, they came into possession of evidence that Mr. Armstrong used or possessed alcohol on each of those days. And with respect to the incident on July 24th, 2019, Mr. Armstrong candidly admitted to the probation officer that he had been regularly consuming alcohol since December of 2017. Next, the U.S. Probation Office charges in violation of the special condition requiring that the defendant submit to remote alcohol monitoring. Representatives of the U.S. Probation Office would testify that Mr. Armstrong failed to submit to the test as directed on October 3rd, 2017 and October 6th, 2017. Finally, Your Honor, the U.S. Probation Office charges that Mr. Armstrong violated the special condition requiring him to participate in sex offender treatment. Representatives from the U.S. Probation Office and his sex offender treatment provider would testify that Mr. Armstrong was suspended from his sex offender treatment program on July 25, 2019, for withholding information regarding his alcohol abuse. As the court indicated, the government and the probation office anticipated that Mr. Armstrong is going to admit to each of these violations and that the probation office is asking the court to allow it to withdraw the fourth charge violation. Thank you. Thank you. Mr. Armstrong, would you stand again? Do you understand you have a right to a hearing to contest these charges?
Yes, sir, Your Honor.
Do you understand that at the hearing, if the government calls witnesses, you may have the right to have questions asked of them and to object to the evidence they may offer?
Yes, sir, Your Honor.
Do you understand that you would also have the right to present evidence on your own behalf, and that includes the right to subpoena witnesses to testify?
Yes, sir, Your Honor.
Do you understand that if you admit these charges, there'll be no hearing on the charges?
Yes, sir, Your Honor.
Do you understand that by admitting these charges, you will be subject to penalties?
Yes, sir, Your Honor.
And those penalties, you got to switch it up every little bit. And those penalties may well include spending more time in prison.
Yes, sir, Your Honor.
Do you understand that if you concede you committed these violations, the only remaining issue will be the punishment to impose?
Yes, sir, Your Honor.
Mr. Armstrong, do you wish to have a hearing on whether you committed these violations, or do you wish to concede you committed them?
I wish to concede that I committed them, Your Honor.
Thank you. You may be seated. I find the defendant has knowingly and voluntarily waived his right to a hearing pursuant to Rule 32.1. I also find that the waiver was knowing and voluntary. That the waiver was knowing and voluntary, and that there's a factual basis for the admission. Mr. Casey, have you received a copy of the revocation report in this case? I have, Your Honor. Do you have any objections to its contents? I do not, Your Honor. Mr. Morgan, have Have you had an opportunity to review with your client the revocation report in this case?
Yes, Your Honor.
And does he have any objections to its contents?
Oh, boy. We have some disagreements about the sentence, but nothing in terms of the guideline recommendations, if that's what the court's asking.
No, I'm asking about the contents of the report, and I will get to the guideline calculations in a moment.
Okay. We have disagreements with probation's characterization of his access on the internet for vindicating himself as it's put in the report. We haven't gotten into the details of this case yet. I'm sure we will, but he was on a national television program called To Catch a Predator.
I just enjoy that he brings that up right off the bat. Just like
using that as I guarantee Lorne was like, you gotta tell him that I was on To Catch a Predator.
Right, it's like that thing where I just find it funny that it's like the worst thing ever, and they his attorney and Lorne think to bring it up as first thing.
Yeah.
You know what I mean? My subpoena smells like 100% beef burger. I can't. I'm sorry. I'm having trouble hearing you.
So is the court reporter. That's why I'm supposed to wear this. I apologize. He was on a television program called To Catch a Predator,
say it
Your
again.
Honor. Every time Lorne hears the words To Catch a Predator, he just melts a little bit more. That has caused him some unfortunate notoriety. I believe that it's probation's position that he has participated that in that notoriety in a way that is denying acceptance. And Mr. Armstrong does not agree with that characterization of the facts. But in terms of the alcohol violations and his suspension from treatment, those things that he admitted and has no disagreement with the facts in the report.
Okay, well, let's see what we're talking about here. So are you talking about on page 6, the third paragraph talking about the May 4th, 2017 anonymous email?
Yes, Your Honor. That's the part the part of what he disagrees with.
Okay. Here it says, of note, the United States Probation Office had received several anonymous emails from individuals who believed Armstrong was a predator and wanted to see him incarcerated. Armstrong additionally continued to engage with these individuals, attempting to vindicate himself. He sure did. Armstrong also attempted to make money by selling items involved in his conviction, i.e. shirts and mugs online. Did he have mugs? I don't remember mugs.
I don't either. I think it was shirts, and then he was selling like his outfit from the sting and something about duffel bags. I want those duffel bags.
Yeah, I don't think it was. Hey, Pack Loner and TLI, nice to see you. Mugs online. His behavior was being addressed in treatment as it was not conducive to his program in sex offender treatment, since he would not accept any culpability in his case. What is that what you're... Oh my god, come on, Judge Woodcock. Like, what the fuck is this? Is that...
Judge Woodcock is like, we're gonna fuck this up for you.
I know. He's like, oh, you have a stutter and a speech impediment online, so let me just word this very poorly. What is it that... Is that what you're... Is that... Have I read what is in controversy here?
Yes, Your Honor. In part, what it is that these emails are being sent indicating that Mr. Armstrong is, quote, still a predator. There's been no proof of that. Probation doesn't assert it, but the fact that those emails are even mentioned demonstrates his concern that him trying to vindicate himself on the internet by responding to people on YouTube channels, whether right or wrong, somehow is something that should be considered as an aggravating factor for the court.
Well, it sounds like we have. That's not a little disagreement. We have a fairly significant disagreement on that aspect. Not on that alcohol consumption, but on his actions that are listed as I described. So as I understand it...
man!
Here we go.
This is great!
Here we go.
This is great!
So sorry. I'm so excited. So as I understand it, he was on October 18th, 2017, and I hope he would have put the day that he turned 37 today. He traveled in interstate commerce with the intention to engage in illicit sexual contact with a person he had met online who he thought was Kyla, but that's either he says Kyla or she misspelled.
I imagine he probably said Kyla.
Kyla, a 13-year-old minor, and it was actually an undercover sting. He left Tennessee, and then he traveled to Bowling Green, Kentucky, when he was arrested. He then pled guilty to that charge and was sentenced to 60 months and placed on incarceration and was placed on supervised release for life. And he ultimately found his way to Maine. It strikes me that the charge 5, which is the defendant shall fully participate in sex offender treatment, is, in part, related to whether he's involved in the conduct that I just read. So how do counsels wish to proceed? Is there a disagreement here about the facts that the court should consider? Or are these facts not relevant as far as the prosecutor's concerned? Your Honor, may I check with the probation office? Mr. Casey speaking with Mr. Turgeon and Mr. Morgan. Mr. Casey, Your Honor, I apologize for the delay. It may take a couple of minutes for defense counsel and the probation office to sort through this issue. If we could have a brief recess, that might be productive. Sure. The revocation report interweaves two issues, and the first issue is ongoing alcohol use and his inability to control his alcohol or alcohol intake. And the second, from my perspective and looking at it, was his, I'd say, flirtation with sexual misconduct. And the first is, as I've indicated, I just read aloud this characterization that the United States Probation Office made about his attempts to vindicate himself, at least in the probation office's words. But then on October 8th, 2018, there was an anonymous email that reported that he was attempting to arrange for an unknown female to send him sexually explicit pictures through the mail so probation would be unable to find the images. And then the next day, he admitted that he had requested the images, and he also admitted purchasing a smartphone without permission. So I bet he told Maria, well, I'm telling you the truth about it now.
Yeah, why does it matter? I'm telling you now. Also, I hope he just went to Walmart and got, like, a fucking $200, like, smartphone, because holy shit, smartphones are expensive.
Yeah, he probably got, I mean, there's those, like, Samsung Galaxy double XTs, or they're like the ones that are like $75. So.
Yeah.
But he spends, how much does, because he tells Ramona, like, what, I'm not worth $60 a month or something, because he pays like $60 a month for a burn phone.
It's
I think it's expensive.
It was something like that,
I think
yeah.
it was over 50. From what I remember.
Lorne is stupid. That's the conclusion here. Lorne is stupid.
Yes, I don't know how we came to that conclusion. And then he's ultimately placed on computer monitoring restrictions. It says his internet access was not reinstated due to the risk he posed to the community based on his unwillingness to stop engaging with women, whom he had never met, online, and that their ages were unknown. And then on March 20th, 2018, he in the mental health and substance abuse counseling was terminated because he made minimal progress. The government finally, after, 6 years, because he was released in 2012, finally went, get the fuck out of here. Like, we don't...
Oh, man, does that mean he doesn't have Allie anymore? Damn, poor Allie not getting to see the joy of Lorne Armstrong.
I need to talk to Allie. She's beautiful, but she's married.
She's married to a cop and they live on a farm, but I don't know personal information about her.
And then there's this business about March 28th, 2018. Armstrong had no significant reactions to the polygraph, but disclosed after the examination he had other people access the internet for him as he was prohibited from using the internet, and he would have females who he met online and had never met. I guess that means personally. Call him and make changes to his YouTube account on his behalf once or twice per week, which violated the computer and internet monitoring condition. So my concern is, obviously, how much of this is he admitting? What is he denying? And whether it matters for the purpose of what I do on the revocation. So I'm going to direct counsel to try and respond to those questions for me. Court will stand recess. Court recess from 10:38 a.m. to 10:59 a.m. Counsel?
Apologize for the delay, Your Honor. We've had a chance to speak with the attorney for the government and probation. Mr. Armstrong is willing to admit that, well, each of the paragraphs that the court addressed, but in particular, the May 4th, 2017, but with the important understanding that probation has not corroborated any of these emails accusing him of being a predator or in any way confirm that they were true. So what I didn't want to do is admit the facts to the court and then be arguing differently at sentencing. So...
Well, the way I interpreted this, and maybe it may help or may not, He has been convicted of traveling in interstate commerce to engage in illicit sexual contact with a person who he believed was 13 years old. That, I think, fits the definition of a predator.
Certainly, Your Honor.
So I don't assign any particular weight to somebody who is claiming, if that is what they are claiming, that he continues to engage in predatory conduct. I don't see any evidence of that.
Okay.
You should go on YouTube there, Judge Woodcock. Although there is a suggestion that he's flirting with it. But what I still think that if somebody who maybe watched this show and takes it upon themselves to anonymously send an email to the probation office saying, we think he's a predator because he was caught in a show that was designed to catch predators, that's sort of what's that word?
Tautology? I don't know.
Whatever.
Exactly, understood.
Okay. Does that help?
It does, Your Honor.
All right. So I gather that the defendant does not have any objections to the contents of the revocation report as presented.
No objection, Your Honor.
The court makes the following guideline calculations. The grade of violation is C. The criminal history category I. The guideline range is 3 to 9 months. The statutory range is 3 years. And the term of supervision is life. The $100 special assessment has been paid in full. Is there any objection to these findings on the part of the government? No, Your Honor. On the part of the defendant?
No, Your Honor.
You may be seated. Mr. Casey, would you like to be heard on sentence? I would. Thank you, Your Honor. Your Honor, in this case, the U.S. Probation Office is recommending that the court sentence Mr. Armstrong to a term of imprisonment of 6 months, to be followed by a lifetime term of supervised release with all the conditions set forth in the revocation report. Your Honor, Mr. Armstrong was released November 5th, 2012, and it appears from that report. See, my dyslexia almost made me say 2021, and it confused the hell out of me for a second. And it appears from the report that he made it almost 3 years before he started letting alcohol interfere with his life again. Notably, in the pre-sentence report from his Kentucky case, he acknowledged that he might have a problem with alcohol and that he'd be amenable to treatment. So we have the level of self-awareness. This is the judge. I don't know about that. What he said in the pre-sentence report, as I read it, was he had begun consuming alcohol when he was 20. He last drank alcohol a couple of days prior to his arrest on October 18th, 2017. He described himself as somebody who drank socially and indicated Budweiser Light was his drink of choice. Tony don't do well on Bud Light, on Budweiser. He indicated that he typically drank beer on the weekends and would drink to the point of intoxication if he was upset. I think you believe if he were upset. I mean, come on, Judge.
If he were upset.
He expressed that he believes he has a borderline problem with his consumption of alcohol, but he feels he would benefit from treatment for alcohol abuse. He denied any history of blackouts, and he denied any history of drug abuse. Okay, Lorne only admitted that because he thinks it would take any sort of blame away from him, because he's like, I do drink a lot, but he still can't bring himself to say he's an alcoholic, because to him he feels like he lost, basically.
Yeah, he can never assume full responsibility, like, ever.
And then the blackouts. I mean, he drank so much in those calls, he doesn't remember what he says the next day. So
he'll be like, I don't remember saying that.
Yeah, he'd just call and be like, hey, honey, and they're like, you just screamed at me all night. What? Huh? So I think he sort of had it both ways back at when, in the pre-sentence report, he was a social drinker, but he realized that maybe he had a problem, and maybe he didn't. I'm not so sure I'd characterize it the way you did. Then he recognized he had a problem. I think he was equivocating back then. Mr. Casey. Understood, Your Honor. Well, he certainly expressed that he was willing to undergo treatment back then. The court. Right. Mr. Casey, which is something that there's no indication of that now. Not only is there no indication of that, but he's covering up his drinking, and when confronted about it, he's lying about it. He's even lying during polygraph examinations about it. And this is what ultimately led him to being removed from his sex offender treatment, because he couldn't even be honest in sex offender treatment about his drinking. And ultimately that, the court, yeah, I saw them as interrelated. He was, and it's hard to know. I mean, I don't know Mr. Armstrong, but it's very hard to know how much of his online conduct and his inappropriate, I would say, online contact with females is related to drinking, and how much of that does he drink and then lower his inhibitions and go online and do foolish things, or is the alcohol related to his acting out online? Mr. Casey, the way that I read the report, Your Honor, and in my discussion with the probation office, my sense is that the sex offender treatment provider believed that, as a general matter, consuming alcohol and lying about it is counterproductive to sex offender treatment. The court, well, of course. So,
No shit.
So we just got through 16 pages, so that's where I'm going to have to end it for tonight. So we'll pick back up, with Mr. Casey just sort of roasting Lorne about all of his shit. So hopefully in the next few days, or maybe next week, if Cybersqueak is available, we can finish this.
Yeah, that'd be fun.
Whoops. No. Come here.
No.
Again, Cornville Three-Way is next in about a half hour over on his channel, and then after, around the time, like 2 hours, I don't know if he'll be done, but it'll be around the time he's finished, Callie and Honest will be streaming at 10 p.m. Eastern. So I appreciate Cyber for coming on.
Yeah, no problem. It was fun.
It was very fun. And I hope to see everybody over at Cornville stream, and I hope you guys have a nice night. Bye.
Bye.